Hey, Kevin Mottley at the Mottley Law Firm. I recently did a video on to what extent in a personal injury case, like a brain injury case, the insurance company involved in the case and their lawyers can discover, find out, get copies of an injured person's medical records. And I explained how they can do that so that they understand the entire medical background of the person who's saying that they're injured. A related question is, how can they find out information like that? There are a number of ways. One of them I'd like to talk to today is a medical examination. So in federal court, under the United States rules of civil procedure that govern district courts, and also in the Supreme Court of Virginia's rules that govern state courts, both sets of rules have a rule that allows a party involved in a personal injury case or any case that involves the mental or physical condition of a party. It allows other parties to request the court to order that the injured person submit themselves to a medical examination or a physical or mental examination by a healthcare provider. So in a brain injury case, for example, we will often get requests from the insurance company and their lawyers to have our client go and be examined by a person like a neurologist or a psychiatrist or perhaps a neuropsychologist. And those sorts of requests are commonplace. They are governed by whatever rules the court puts in place in that case as to the parameters of the examination. And that's usually where there is a little bit of a dispute sometimes between the parties as to what an examiner can do. What can they do during the examination? And that can get into, okay, well, what sorts of questions can they ask? What sorts of tests can they give? That sort of thing. So that's a very common thing that happens in personal injury cases, especially significant personal injury cases like we handle. So I hope that answers your question. I'll have some other videos about other ways that they can find out about your medical history. Thanks a lot.